For the record, Daryl Perry. I live in Keene, New Hampshire, and I've had my free speech violated on the campus of Keene State University, or Keene State College. When I first moved to New Hampshire in 2012, I was walking around campus with a friend, and we were informing people about a rally that was happening at the State House in a couple days' time. And, well, I was then served with a "do not come back onto this property indefinitely" piece of paper by the Keene police. That was since thrown out. Found an attorney to do some pro bono work and wound up getting my no trespass onto the college revoked, which means that I'm now allowed to go to the only art museum in the entire city of Keene, which is on the campus of Keene State College, because right now Keene State College, and I believe all of the other state-run colleges in New Hampshire, have restrictions on when people can exercise their right to free speech. If I, as a political activist, wish to go onto campus and distribute literature, according to Keene State, I need to find a student organization or a student to basically sponsor me. I would then have a fixed table from which I could not call out to anyone. So if you've ever been to a fair or any kind of event, you know, the carnival board, "Hey, come over here, check out what I've got." Can't do any of that. You cannot call out to people. You must stay behind the table, and the table must be in a fixed location. Well, what this bill does on page 1, lines 11 through 17 are really the operative parts of this bill. It says that expressive activities protected under this section shall include, but not be limited to, all forms of peaceful assembly, protest, speech, distribution of literature, carrying of signs, and circulating petitions. I will pause right here to mention about the circulating petitions, because that's very important to me as someone who is neither a Republican nor a Democrat. In order for me to run for office, for anything other than a nonpartisan city office, I have to collect petitions. And it's not easy finding public places that have a lot of people. Colleges have a lot of people. So this would protect the rights of minor party and independent candidates to circulate nominating petitions on the campus of the college. Currently, they would need permissions, and then again, they would be given a table from which they could not call out to anyone, and they would have to stay behind the table at all times. And if they violated the agreement, and I use the term agreement loosely, they would be removed from campus and would not be able to exercise any free speech rights on campus for basically up to the administrator's discretion. Lines 14 through 17, again on page 1, state that any person who wishes to engage in non-commercial expressive activity as a component institution of the university system may do so freely, provided that the person's conduct is not unlawful and does not materially and substantively disrupt the functioning of the institution. So again, this protects and codifies that the outdoor open areas of college campuses are open to all forms of peaceful, lawful, non-commercial speech. Specifically, and most importantly in my mind, is political speech, which courts have routinely found carry extra protections. You must go above and beyond to protect political speech. And this bill, at the very least, does that. And at the very most, it, again, protects all forms of non-commercial, lawful speech on campus in outdoor areas. And I will take any questions.
Are there any questions from members of the committee? When you, go ahead, Representative Adams.
I'm trying to find the part where I'm all for free speech, and I believe that some of our speech is limited in certain areas, and sometimes for good reason. Is there, where in this legislation does it state the locations that you just expressed? I'm trying to find that. Because
There is somewhere in here, and if you give me 1 second, it does mention about indoor and specifically outdoor. I believe that on page 2, line 5, the outdoor area of institutions, well, that's specifically about community colleges on page 2, line 5 on page 1 as well, the outdoor areas. And it does specify that the colleges may maintain and enforce reasonable time, place, and manner restrictions when such restrictions employ clear, published content and viewpoint neutral criteria. And they cannot restrict spontaneous assembly. So spontaneous activity can't be restricted in accordance with this statute. And line 18 and 19, nothing in this section shall be interpreted to limit the right of student expression elsewhere. But specifically, line 5, it does say the outdoor areas.
I'm concerned a little bit that this allows somebody, or might allow somebody to come in there with a loudspeaker, let's say, and have their demonstration outdoors, right? So it's, in the quad somewhere. I've got a nice loudspeaker, and I'm going to make a very rambunctious presentation or reading of the Declaration of Independence, coming up next month.
I think a loudspeaker or prohibitions on having a loudspeaker would certainly be construed to be a reasonable restriction,
Okay.
Because
That's where I'm going.
it would specify, like no one can use a loudspeaker. They could say that, but they couldn't say no one unless they're having a rock concert can have a loudspeaker. So they could prohibit, amplified voice.
So that leaves it up to, say, the university or the authorities at that time to determine what reasonable is.
Right, and again, I do believe that they would need to have something actually in writing. If they just make it up on the spot, then that is very troubling to me. And then I believe line 24 comes into play, that if the court finds that a violation has occurred, then the aggrieved person shall wind up being awarded not less than $500. So if the college does try to infringe on someone's rights, there is a penalty for doing that, other than just, don't do that again!
Okay, so it could be college, sorry, one more question.
One more.
So it could be a college, it could be a town, it could be any entity that owns a public space.
This specifically is dealing only with the university system and the community college system. So it would not apply to public property owned by, say, the city of Concord.
Thank you.
Are there other questions? Yes, Representative Wolf and Representative Myler.
Thank you, Mr. Chairman, and you actually set me up. Do
Glad-
these rules that are being proposed currently apply to open public spaces such as the city of Concord or the city of Keene or other places?
There are, in most of the cities and towns, as far as I am aware, there are certain places that are called commons, where there cannot be restrictions on the use of free speech. So in Keene, for example, Central Square is not a town park, it is a common. So the city cannot regulate any use of that property for free speech purposes. They can't institute a curfew, so they can't say, you can't be in the town common after 11 o'clock. But if it were a park, they could do so. So there are various degrees of leeway that municipalities have for public property usage, and that depends largely on the legal status of what that public property is.
Further questions? Representative Myler.
Thank you, Mr. Chairman. Thank you for taking my question. My understanding here then, based upon the language of this proposal, is that someone couldn't just walk onto a college campus and do whatever they want to. Is that correct?
Currently, you can't. Under this, you would be able to, if it's spontaneous or, with prior approval, you would be able to walk onto a college campus and engage in lawful, non-commercial, expressive activity.
As a follow-up. I'm looking at line 7. It introduces it by saying an institution of the university system of New Hampshire may maintain and enforce reasonable time, place, manner restrictions, etc. So that to me would indicate that if I wanted to do something on a college campus, I've got to there's some kind of a form or there's some kind of authorization that I need to have before I actually do it. Is that correct?
That's one interpretation of this. There's also the last word of line 9 and the full line 10. Any such restriction shall also permit spontaneous and contemporaneous assembly. So if there's a spontaneous thing that happens, then the time, place, and manner restrictions adopted in accordance with line 7 could not restrict something that is spontaneous.
Thank you.
Are there further questions? I got one for you. One of the previous speakers, indicated that this is the best that we can do at this time. Something to that effect that I wrote down. So in looking at line 11 here, when we talk about expressive activities, and then it goes on, but not limited to, and it lists some of those things. Is this going to provide clear definition as to what an expressive activity is, or without really defining it better than this, we are going to have some problems?
I don't think you need to define it any further because, again, you're not defining it only is these things. It says it includes but is not limited to, and then gives some examples of expressive activity. So, a song and dance number could be considered expressive activity. It doesn't mention it here, although depending on how many people are singing and dancing, and for what purpose, it could be considered a form of protest. So I don't think you necessarily need to list out more examples of expressive activity. I would recommend that the members of the committee read the Guide to Free Speech on Campus put out by a group called FIRE, which is the Foundation for Individual Rights and Education. You can download the PDF for free on their website, and hopefully a representative from FIRE shows up in a couple of weeks, because they do a lot of really good work trying to remove the regulations on free speech on college campuses. And last year they actually put out a press release stating that they would, if they have to, go to court in all 50 states to get the free speech regulations on college campus repealed. And they've already had success in Virginia. So you might also want to look at what the regulations were that were adopted in Virginia that did something very similar to this, if not the exact same thing, that opened up all outdoor areas of colleges to lawful, non-commercial forms of speech.
Yes, Representative Smith.
Thank you, Mr. Chairman, and thank you for taking questions. My concern about this is, would this limit the state university's ability to control hate speech and violent incitement on campus? Wouldn't that be a risk of campus disruption and exacerbate tensions? That's my concern. Would it limit the university's ability to limit hate speech?
If it is construed to materially and substantively disrupt the functioning of the institution, then they would be able to limit it. You mentioned about violence. Well, violence is an unlawful activity, so they most certainly would be able to regulate violence or violent activity, because again, those are unlawful activities. But just somebody saying something or holding a sign that somebody doesn't like, well, that's, sort of one of the problems that you run into when you hold any kind of sign, because I've held signs saying "End the wars," and people get upset. And I've had people say, if you don't want to stand behind the troops, stand in front of them, suggesting that my anti-war stance is somehow grounds for execution. So there are people that, they could take offense to anything. And I don't think that, saying you can't hold any sign that's offensive, because any sign could be considered offensive to someone. I hope I answered your question. Apologies if I did not.
You partially answered it. May I follow up, Mr. Chairman?
Yes, you may.
You partially answered the question. When I was talking about violence, I was only referring to incitement to violence, not the act itself. So my concern is certain types of speech that incite violence, and we have that speech around, is inappropriate to the campus, and would this legislation prohibit the university from prohibiting incitement of violence for whatever cause? And that is my concern.
I'm not sure, and apologies again if I am not directly answering the question, but I'm not sure if you're referring to like the fighting words doctrine, and that's one of those things similar to what courts have ruled on obscenity of we can't define it, but we know it when we see it sort of thing. But again, as long as there's not a policy that restricts on content or stifles true free expression, then, if somebody is walking around with a sign saying, "Kill the Jews," that could be considered, inciting violence, or depending on what the method of protest is, it could actually be something other than just holding a sign. They could be having a call to action, which there are probably regulations and restrictions on that as far as what determines when something crosses into or from free speech to inciting a riot or inciting violence, and I know that there are already statutes on that. So again, it seems to me that would then fall into line 16 of you don't have to allow unlawful activity.
Are there any more questions? Thank you very much.
Thank you.
We have